There is a quasi-judicial body inside the IRS called the Independent Office of Appeals. No one voted to create it. It appears in no law Congress ever debated in public, and it has operated since 1927, making binding decisions on billions of dollars in tax disputes, with no public record of how it reaches its conclusions. By the end of this, you will understand something about how American power actually works that most people around you will never know. Most Americans have never heard of it. The people who have heard of it mostly wish they hadn't. Here is what it actually is. When the IRS audits you and disputes the result, you are entitled to a hearing before you go to court. Not a courtroom, not a judge, not any body the Constitution names. You get a conference with an appeals officer. That officer is an IRS employee. She works for the same agency that just told you that you owe money. Her office may be in the same building. Her paycheck comes from the same budget. She will listen to your case, weigh it against the government's position, and reach a decision that is effectively final for most taxpayers. No transcript is made. No public record is produced. The settlement, if there is one, is sealed. This is not a side process. The IRS Appeals Office closes well over 100,000 cases a year and manages disputes involving tens of billions of dollars in contested tax liability. It is one of the most consequential adjudicative bodies in the country. It has no courtroom. It has no public docket. It has no obligation to explain its decisions in terms the public can examine. And for 56 years, from its creation in 1927 through the Taxpayer Bill of Rights legislation passed piecemeal in the 1980s and 1990s, it had no statutory basis at all. No Congress voted to create it. No president signed it into law. The IRS built it through internal policy, Treasury regulations, IRS manual provisions, administrative layering. It existed because the IRS said it existed. Its authority derived from agency custom, not from any source of law a taxpayer could point to and successfully challenge. When Congress passed the Taxpayer First Act in 2019, Public Law 11625, it formally named the office in statute for the first time in 92 years of operation. That is presented as reform. Read the fine print. The law gave the office a name. It did not give taxpayers the right to know what the appeals officer was told before they walked into the room. Because here is the part that is completely, perfectly, structurally legal, and this is where it should actually concern you. The appeals office operates under what are called ex parte communication rules. The stated purpose: appeals officers cannot have private conversations with IRS examination teams about your specific case without you present. A protection, in theory, for neutrality. But those rules do not stop the IRS Office of Chief Counsel, the government's own legal team, from advising appeals officers on legal strategy, on how far the agency is willing to move, on what pressure points exist in your file. Those conversations happen. They are shielded by attorney-client privilege and the deliberative process doctrine. You were present for the conference. You were not present for everything that shaped it, and the decisions that come out of those conferences set no precedent. A ruling in your favor is invisible to the next taxpayer in the same situation. A ruling against you is equally invisible. Every case is siloed. The body adjudicates in enormous volume in private with no accumulation of public reasoning. It learns. You cannot. Remember, no one voted for this structure. No one put it to a vote after it was built, either. Consider what that means for the architecture of accountability in every other agency that holds quasi-judicial power. The IRS Appeals Office is not an anomaly. It is a model. Dozens of federal agencies maintain internal adjudicative bodies: the Social Security Administration, the Department of Labor, the Securities and Exchange Commission, each with its own hearing officers, its own closed conferences, its own sealed outcomes. The IRS Office of Appeals is the visible version of this structure. Most of its counterparts are less visible. The original purpose was efficiency. Give taxpayers a place to resolve disputes before they reach tax court. Reduce the federal docket. Keep cases from becoming expensive for both sides. That is a legitimate goal. The tool worked, and in working it became indispensable. and in becoming indispensable, it became untouchable. That sequence is not a design flaw. It is how durable power is built inside a government. Make yourself useful first, make yourself permanent second, make yourself unaccountable third. The Taxpayer First Act gave the office a name in law after 92 years. It did not open a single conference to the public. So the question you are left with is this: if the most powerful tax collection agency in the world ran a binding internal court for nearly a century with no statutory authority, and Congress only acknowledged it existed when it could no longer avoid doing so, how many other bodies are operating the same way right now that have not yet been named?